Okay, we're finally into wills and trusts. Alright, so probate is where somebody's property typically has to go to probate court after they die. Trust can sometimes get somebody out of having to have their will probated, but trusts are a little bit expensive typically to do, so most people die either testate or intestate. They have a will and they still have to go through probate, or they have no will, which is intestate, and they have to go through probate. Okay, so a will tells other people how to dispose of your property after your death, and typically they're governed by the California Probate Code in the state of California. Okay, so a testator is a person who creates a will, and this is if you have any sort of property, or even if you don't, if you have kids, you can kind of direct what goes on a little bit after you die. But especially if you have kids, it might be something to think about, potentially having a trust. But there is a statutory will that you can do. So at least do that, if nothing else, especially if you have kids. Okay, the will has to be able to stand on its own. What does that mean? It means that no other outside evidence can be used to really help explain it. And if it's required to look at other documents, then that will probably is not a good and valid will. It is confusing though, because as long as it refers to something valid, like another valid legal document, then it can be incorporation by reference. So a lot of times my clients ask me to do a pour-over will, which a pour-over will refers to a trust that says if nothing in this trust if something in this trust didn't get carried over, the pour-over will pours it back into the trust, and then it goes to the descendants, basically, or whoever is named on the trust. So if it's a valid legal document, I guess you could say, and it's properly referenced, you can incorporate it by reference, but otherwise, not so much. Okay, so wills typically have to be written or typed and signed, and as you know, in law we sign things in blue typically, and typically a will has to be witnessed, and usually they want to have 2 witnesses, and it has to be clear as to who's going to get whatever the property is, the kids are, that sort of thing. Oral wills in California are not legal, so especially if you have kids, you want to make some sort of preparations for who's going to take care of them after your death. Okay, so in order for somebody to make a will, they typically have to be over the age of 18, and they have to be mentally competent. So sometimes when people are really old and they decide to change their will, or they decide to finally do a will, we videotape them doing that to show that they are mentally of sound mind and body, and they're not suffering from dementia. All right, holographic wills are completely valid if you follow the rules, and can quickly and easily help you, plan for, or our clients plan for, their death. All right, so in the state of California, we don't have to witness a holographic will, but honestly, in practice, it's better to go ahead and do that. It is better, and it really should have the date in it, and it should be clear that the person understands, this is in case of their death. So holographic will is in your own handwriting, and you would need to sign it. And I highly recommend it's dated. I highly recommend that you make it clear that this is in case of your death, where do you want this property to go to, name the people, and I would recommend having 2 witnesses as well. Now this one does have the date, okay? I have 5 children and wish to leave all of my assets after my debts are paid to all of my children except Brian. I believe Brian died in the Malaysia Airlines crash, but his body has not yet been found, though he was confirmed to be on board. Okay, so I have 5 children. Okay, so that we could figure out who those people are, even though they're not named. And I wish to leave all of my assets, that's pretty clear, everything, after my debts are paid, okay, to all my children except Brian. But she could have done a better job about talking about when I die. She does have will on it, so it'd probably be okay. She does have the date. We can figure out who her 5 children are, but really it should talk about her death, and it should really be witnessed, and it should have blue ink signatures, but this would probably be upheld if I hadn't written it for Jane Sansom, which is what I did. Okay, so there's your real answer. You can read that real answer on your own. All right, so probate is, finding all of somebody's property. Why a trust is different is because you can send the trust to the bank. You can send it to different financial institutions and have them distribute the assets based on that trust. But with probate, with a will, most banks and stuff are waiting for the probate court kind of tell them what to do with that property and who to release it to. Okay. All right. So typically, when someone dies, we look at their assets and we look at their debts. Okay. So for example, Jody has $100,000 in cash. So maybe, in her bank account or something, or all together, looking at different pots of money. However, she has debts totaling $65,000. Okay, so you have to take the $100,000 in assets from everywhere, all added up. Take all the debts from everywhere, every credit card, maybe she has 10. Okay, and then you subtract all the debts from all the assets, and that leaves $35,000, which can potentially be distributed to her heirs. Now, it will be taxed typically. We're not going to get into the tax too much, but not just to bring that to your attention, so to speak. Okay, per capita versus per stirpes. Okay, under a per capita distribution system, it's divided among all the existing heirs equally. So if somebody has 3 heirs, they get 33%. If you have 2, you get 50%. If you have 4, you get 25% each. Okay, by a per stirpes distribution system, the property is divided up by rankings. Okay, so let's look at it on the next slide. All right, so Donnie is a testator, and he leaves his money to his 2 daughters, Ida and Cora. Okay, but unfortunately, both Ida and Cora die before Donnie. So here's how this works, okay? Ida had 2 kids who have to share her 50%, so they each get 25. But Cora only had 1, so her kid gets 50%. And just going back to the slide, there's questions about wills and things on the final examination. All right, codicils is when you modify an existing will. So, being a lawyer, not to say that I'm incredibly rich, which I'm not, but just being a lawyer, I had a will and trust that I prepared when I got married to my husband, just because I know the law and I knew how to do it, and it's just being paranoid and worried about stuff, I did it. So my husband and I were married for almost 10 years before we had a kid. So then we did a codicil because we want to make sure that our kid goes to certain relatives in case we die. And we don't want her to have to go to Child Protective Services while they figure it out. We just want her to go straight to a certain relative if we both die. If one of us dies, the other one gets to take care of her. But if we both die, we want to make sure she goes to a certain relative and not have to wait for probate court to figure that out or whatever. So we did a codicil to her will and our trust. And that's very common when you have kids or you have another kid or so many divorces, to go ahead and do a codicil or an amendment, basically. All right, challenging the will. Typically, if people have any assets whatsoever, they will have like a no contest clause, which says, you know, if you disagree with the way I said to do this and you challenge me, then you get nothing. Okay. Now, the interesting thing is if I really didn't have to do a will with my husband, I was paranoid and did one anyway just because I'm an attorney and that's the way attorneys think. But, you know, if he had a will or I had a will before we got married, then all statutes pretty much assume that once you get married, you meant that will to change. And you just didn't get around to doing it, typically. Unless there's like a prenuptial agreement. Okay, intestate. That's when there's no will. And, you know, even if you have no assets or you have a lot of debt, it's just really important, especially if you have kids or you have parents still living, just to try to make their life easier, to try to have a will. And there's a California statutory will. I'll make myself a note to try to post it if I didn't already do that. All right, appointment of administrator. You can read that slide on your own. All right, so hint, hint, nudge, nudge. This is a really important slide as well as the next one. Okay, to figure out for the final exam. And notice the difference. Okay, there's community property and quasi-community property. Okay, and it's important to pay attention to the difference because I have two questions on the final exam, and one is for community property and one is for separate property. And if you notice, if somebody dies and they leave a spouse living, then all the community property goes to the spouse. But look, it can be different if they're separate property. So you need to read those. This cheat you can read on your own. This is what we're trying to avoid when we do a will. In general, though, we're trying to make sure that property does not go to the state. And there's a whole website called Unclaimed Property. And there's one for the state of California and for every state where, you know, unfortunately, people don't write wills and trusts and money does revert to the state. Okay, trusts. We already kind of been comparing and contrasting those all along, but read those on your own. And I thought this case was really interesting and you might want to read it. All right, so don't forget to do your lovely questions.